My ladies, my lords, I will continue in relation to issue 4 with our primary argument relating to how Article 13 should be applied in the context of Schedule 6 to the 2011 regulations by assuming that the full rigour of the regulation and its interpretation should be applied. As I've already submitted, my first point is that actions can be related even if they're not both yet having their cause of action as maintenance. Secondly, that more and more decision I'll come to in a moment is wrong to suggest otherwise if it does so. Excuse me. Thirdly, that it is only the court second C's that must have maintenance as the cause of action in the proceedings before that court for Article 13 to be engaged. And fourthly, that in applying the regulation, one must adopt a broad common sense approach. My ladies, my lords, I've already dealt with the first of those. Can I turn to the decision in More and More? This matters, as I say, because in the judgment of the court below at MS 2241, one can see from the judgment of Lady Justice King at paragraph 89, that's to say MS 2241, that the decision was held to have been, as it were, determinative, that the answer to the premise of appeal was found in the decision in More. One can also see at the end of that paragraph the sentence that, the penultimate sentence of that paragraph, that the comment that it must be remembered that there was a live application for financial relief in Spain, and notwithstanding that, it was held that wasn't a matter of maintenance, and therefore the matters in England and Spain could not be related. And the whole gist, I say, of paragraph 91 of the judgment below is that the Scottish court in this case has to be seized of a maintenance issue before the English court has a discretion to stay under Article 13. And so I'm going to deal now, if I may, with More and More. The decision of the Court of Appeal reported 2007, Volume 2 of the Family Law Reports at 339. It's in the Primary Authorities volume at tab 9, thank you, and it's MS 254. The issues that were determined were an application by Mr. Moore to set aside the grant of leave to Mrs. Moore to apply under Part 3 of the 1984 Act. And, my ladies and my lords, I've already referred to the comment at paragraph 7 at MS 343 about the disturbing nature, as it were, or what was called a sterile jurisdictional issue, and the fact that it had taken up 4 days in front of a judge of the division. The key aspect, of course, in this case was that there had been a divorce in Spain, and then Mrs. Moore was seeking to invoke the jurisdiction under Part 3. If one turns to paragraphs 22 to 24, the short version of that is that by the time it came for Mr. Justice McFarlane to determine whether or not the leave under Part 3 should be set aside, the Spanish court had taken the view that it had no jurisdiction to deal with any financial issues. And one can see on the same page, MS 260, at paragraph 17, the nature of the application that was considered to be before the court, if at all, which both Mr Justin McFarlane and the Court of Appeal considered was an application to effectively bring the matrimonial property regime to an end, to deal with issues relating to marital wealth rather than maintenance, or what we would call a needs-based claim. And it's important, I say, to look at how Mr Moore ran his case in order to decide what the Court of Appeal actually determined. If one looks at, paragraph 28 at MS 261, one can see there the suggestion was that both the English Part 3 application and the potentially pending if the appeal was allowed, application in Spain were maintenance applications, or within the scope of the definition of maintenance at the EU level, and therefore the court here had jurisdiction to stay under Article 27 brackets or Article 28. And I say at this point, there is no independent consideration of Article 28. There are 6 references in the Court of Appeal judgment to Article 28. On each occasion, they appear, as they do in paragraph 28, preceded by Article 27, and it has all Article 28, or the shorter version of that. And so that was how the case was run. The case was decided, one can see on the next page, paragraph 30, that the husband's application was not a claim for maintenance, and one can see that the stay was refused on that basis. On appeal, well, before I come to that, one can see also at the end of paragraph 31 a key feature that was the case according to the evidence before the judge at that point. There were no longer, and could not be in the future, combined proceedings in Spain which would deal with both the ending of the marriage and maintenance. So that was how it was run at first instance. On appeal, one can see at paragraph 40, MS 263, the third challenge to the judge's decision was that, given that the husband's application in Spain was pending on appeal, it was still pending, and therefore there was a jurisdiction to stay in accordance with, again, either Article 27 or 28. And finally, in seeing how it was argued, one has paragraph 56, MS 265. The argument there was, since there was no other court, whether earlier or not, seized of a maintenance application, that there was no power under Brussels I to stay under Articles 27 or 28. So it's worth observing at this point that there was no argument put that even if Mr. Justin McFarlane had been right to characterise the application in Spain as division of marital wealth, not maintenance, there was a independent jurisdiction to stay under Article 28 because those claims were related. And that's how the arguments were put on appeal. One can see, just as a matter of logic, that one cannot, under English law, add up a needs-based claim and a sharing-based claim. The decision of the Court of Appeal in Sharman makes that plain, and we're familiar with, that one doesn't aggregate the basis of which it shares. It's a finite pot that needs to be distributed in one holistic method. And so if one has a needs-based claim in one jurisdiction and a sharing-based claim in another jurisdiction, one would say, as a matter of common sense at the very least, that they are potentially related, they are potentially capable of giving rise to reconcilable judgments. And that analysis doesn't appear anywhere in this judgment. When one comes to the challenge to, or the decision of the Court of Appeal, one has at paragraph 94 on MS 272 the rejection of the decision, rejection of the challenge to the decision that the husband's claim did not amount to maintenance. It was division of marital wealth, not maintenance. And then we have what I say is the key paragraph, which goes beyond what it should, and that's paragraph 95. The April 2006 application was not maintenance. The Spanish application was for division of marital wealth. Therefore, there could be no basis of the applications of Article 27 or 28.
Well, what's wrong with that? Court of Appeal is simply saying we don't reach Articles 27 and 28.
My Lord, what's wrong with it is it's the word therefore as it applies to Article 28. Of course, Article 27 requires there to be the same cause of action. So, therefore works absolutely perfectly and appropriately in the context of Article 27. One has to have the two proceedings have the same cause of action. In Article 28,
it's related.
It's related.
What you're saying is that this judgment lumps Articles 27 and 28 throughout as if they raised the same question, and they don't.
My lady,
and
that's it.
It doesn't anywhere address that whether, even if they were different causes of action, one for division of wealth and the other for ongoing support, nevertheless, they are related to one another.
Yes, and I say, therefore, it assumes the very issue that it purports to decide. There is, in fact, therefore, no answer to this appeal indeed. And one can just see, as I mentioned already, that it is perfectly almost inevitable in cases where there is a needs claim in one jurisdiction and a sharing claim in another jurisdiction, that those two are, at the very least, give rise to the risk of irreconcilable judgments, not just the possibility of an actual conflict between them.
Well, that's an easy statement to make if you're thinking of English law. It's not such an easy statement to make if you're thinking of almost any other matrimonial law, because my understanding is that civilian systems do separate the division of wealth from any question of ongoing needs-based support. Up to a point, Scotland is the same, up to a point. Whereas in English law, we take a global picture of the two, but we're fairly unusual in doing that.
Isn't Milady's point amply borne out by the quotation from the Van den Bogaard case in paragraph 78 of this judgment, Mr. Horton? Lengthy quotation from the Advocate General, and down at the bottom, number 80, paragraph 80 on 269, the other end of the spectrum, where both parties are earning well, an order awarding a lump sum would frequently be intended as a division of assets rather than maintenance in any sense. At that extreme, it will concern rights in property arising out of a matrimonial relationship. So this very much turned on the European notion of maintenance.
What I'd say yes and no, if I may say it that way. The Van den Bogaard is effectively making plain that it's not the nature of the remedy that is determinative as to whether it's maintenance, it's the purpose for which it is granted. So a lump sum order in some circumstances may be relating to maintenance, and in some circumstances may be a division of wealth, and it's effectively looking at how the order was arrived at and what basis it was made, rather than necessarily saying in all cases where you have division of wealth, they cannot be related actions to maintenance applications. And of course, England and Wales is part of the regulation, at least for the time being, and we have to apply that. And of course, that means that where English courts make, as it were, as the lady says, global awards, there is going to be a risk of irreconcilable judgments in that context. So that's why I say, my Lord, it assumes the answer to the question it doesn't even pose, and therefore is no answer at all to the issue in this case. The third point I wanted to make in relation to this is that on the face of Article 13 itself, Article 13 is directed to the ability of a court other than the court first seized. For the court's reference, one can find Article 13 at MS 109 at tab 5 of the Primary Authorities Bundle. What I say is not right is simply to say there's maintenance in one jurisdiction, divorce in another, therefore they can't come within Article 13 because they're not the same cause of action, or indeed they're not in the same regulation. What one has to do is to look not at the issues raised in proceedings, but in the actions themselves. And the authority that I rely on in that regard is that of FKI and Stryborg. That's authority 39 in the volume 3 at MS 1104. And it's essentially, the point I rely on there is just the holding at head note 1. The focus of what is in our context Article 13 is whether they were both seized of an action rather than a particular issue in an action. And so, ladies and lords, I say that deals with the point that there is currently no claim for maintenance within the Scottish divorce writ. Because there clearly could be rather. And the Scottish divorce writ has been repeatedly stayed or sisted at the request of Mrs. Villiers. No doubt, I suspect, as a way of hedging her bets, but of course, whatever the outcome of this appeal, whatever the outcome of any first instance decision or first instance action that survives this appeal, it would be open to Mrs. Villiers to bring a claim for financial provision in the Scottish divorce writ, as long as that is done before the decree is granted. This is not a case where one party has said that they've got no intention of doing that. So without, applying a common sense approach as recommended and indeed suggested by the decision in Sario, I say that is there a risk of irreconcilable judgments? Yes. There's a possibility or a risk that Mrs. Villiers will be able to bring a claim for a lump sum order or a pension sharing order in the Scottish divorce proceedings. And those orders could be, inconsistent with or reconcilable with any order for either periodical payments or lump sum in this jurisdiction under Section 27. There's no need in my submission for an existing or actual conflict. There's no need for an existing claim within the other proceedings. And when one also looks at the other words of Article 23, given the context that there's no Part 3 within the UK and that we don't generally allow bifurcation within the UK, of course, I say it would be expedient to have all claims dealt with in the one court, the court with divorce jurisdiction. And to that end, the broad common sense of the approach that Mr. Justice Moore adopted in the case of N&N, which is authority number 41 in volume 3, at MS 1153, and in particular his analysis paragraph 25 onwards, 1157, which we've summarised in our written case. I can't improve on that. It is sound common sense, and in my submission, is not precluded by Moore, is not precluded by any other considerations at EU level. In particular, there would be no jurisdiction to make an order if the parties were not married. They are, therefore, proceedings in Sweden relate to the dissolution of the very same marriage. The nature of the related actions, my submission, clearly relevant consideration there. And at paragraph 28 on the next page, one can see his analysis of how that would work in practice. So if I may, I move on to the second strand of our argument in relation to related actions, which is that one doesn't, in fact, need to apply the European jurisprudence with the same level of rigour to this area, as we call it, the looser interpretation argument at our written case at paragraph 78 onwards. This is domestic law. And as I say, there are no international law consequences of a court in the United Kingdom deciding to apply its own internal law in a way that's not congruent with the corresponding term in an EU regulation.
Except that precisely the same words would mean different things, depending on whether you had inside the UK or outside the UK.
I accept that. And when one looks at the Kleinwort-Benson case, I took the court this morning to the ECJ case where the court declined to refer, declined to answer the questions referred to it. When it came back at the House of Lords stage, one can see at Authority 28 in Volume 3, there were 4 members of the appellate committee who expressed a view about whether or not the corresponding term in Schedule 4 to the 82 Act must necessarily be given the same meaning as it appeared in the Convention. And one of them said it would be rare if it didn't have the same meaning. The other said it would be desirable to have the same meaning. And the third said we don't need to apply definition with the full rigour. Those references, my lady, are Lord Gough at MS 770, Lord Clyde at 775, and Lord Hutton at 794. So in the corresponding provision, members of the House of Lords indicated that it didn't have to be that way. And of course, there was expressly the case under the 82 Act because the statutory provision says you don't need to apply it in that same way. Of course.
Well, but I mean, surely conversely here, paragraph 3 of Schedule 6 says provisions of Chapter 2 of the Maintenance Regulation apply to the determination of the jurisdiction subject to the modifications. So doesn't that mean it's the same meaning?
Well, my Lord, I would say that's an open question. I would say that it would be perfectly possible in the light of the Kleinwort-Benson case to say, no, it's purely domestic law. Regardless of the existence of that provision, I say the decision of the ECJ would have been the same. That they're not going to give advisory opinions on what is national law, even where national law copies out large chunks of the EU rulebook.
Yes, thank you.
And so all the arguments I say there, even if there were some provision of EU law or some interpretation of Article 13 at the EU level that would otherwise prevent the court from staying the English maintenance claim in favour of the Scottish divorce writ, I say that those don't need to prevent that in circumstances where the same reasoning and the same broad common sense would operate to allow this claim to be stayed in favour of Scotland, to have one jurisdiction dealing with all of the matters arising out of the breakdown of this marriage. And so, again, I adopt the reasons just this morning, and then, as we say, at paragraph 80. Ladies and Lords, in conclusion, I say that this is, unlike more and more, not a sterile dispute. The lady asked this morning how many cases there are under Section 27. My answer was not very many. My submission would be that there might be a good deal more if this appeal is not allowed. Because the way in which the jurisdictions work together at the moment would operate if this appeal were not allowed in an unbalanced way, and they would drag cases into England and Wales, which, on all the assumptions that family lawyers in both jurisdictions had previously made, would be dealt with in the jurisdiction where the divorce was going to take place. And so, on that basis, I say that there is no jurisdiction in a purely internal case. The 2011 regulations did not silently and implicitly repeal the power to stay for non-convenience. Insofar as they did, their ultra vires, Section 22B of the 1972 Act. In alternative, there's power to stay on related grounds. Ladies and my lords, those are my submissions.
No, thank you very much indeed, Mr. Horton. Mr. Lang? No, you've done your job with your little post-its, haven't you?
That's very important.
Mr. Scott.
My ladies, my lords, my allocated time, and I'll be as good at sticking to it as my learned friend Mr. Horton has been, is 2.5 hours. If I may, with the court's permission, what I would like to do would be to reserve a small part of that, say 10 to 15 minutes, in case there is any points arising out of the intervener's oral submissions to which I would wish to respond.
I'd have thought the intervener was more on your side than he was on Mr. Horton's.
He is, very much so, and I'm, of course, very glad of that, but there might even be some points which I would want to take up and run with. But one way or another, if that fits within the court's approach, I would like to be able to do that.
We wouldn't normally allow that.
Well,
So
in
let
that
us
case,
see how
maybe I
things
will.
go.
Very well, very well. My lady, there are 4 issues in this appeal, as between the appellant and the respondent, and a couple of further points which are picked up or raised in the intervener's written case. So far as the first issue is concerned, my lady indicated at the outset of the hearing that that was perhaps not one which concerned the court greatly. My learned friend Mr. Horton took his submissions on that quite quickly.
I think I made a comparative statement.
Yes. Well, I propose to take that quite quickly. So far as issue 2 and issue 4 are concerned, then of course I have the benefit that I am trying to uphold the judgment of the Court of Appeal, and my primary position is that the Court of Appeal got those points right for the reasons which the Court gave. So far as the third issue is concerned, I now have the great benefit of having Sir James sitting here, who will, if I can put it this way, be doing the heavy lifting in relation to the Villiers issue. So I, again, propose to take that quite shortly. So, my lady, there are 2 preliminary issues which cut across more than one of the 4 issues, and so I propose to deal with those on a preliminary basis. And the first of these is a central point which is relevant to at least 3 and possibly to all 4 of the issues between the appellant and the respondent. And that is the favourable treatment which is given by the maintenance regulation to the position of the maintenance creditor. Now, the Court of Appeal did touch on that, but there are 3 authorities which I would wish to take this court to, and they're all to be found in volume 5 of the authorities bundles. Starting quite quickly with
It's
the case.
quite a weird feature of this particular case that the assumption has always been that the wife is the maintenance creditor.
Well, it happens to be the case in this case. In the authorities, the maintenance creditor is treated in a gender-neutral way. And if I refer to the maintenance creditor as she, that is because, in this case, my client is the wife.
I wasn't making that point. I was making a rather different point.
I'm sorry, my lady.
Well, we know very little of the facts of this particular case. They haven't been finally determined. But on what little is available, it is not absolutely crystal clear which of these two spouses is the one who should be the creditor.
Well, my lady, the husband is not making any claim, at least at this stage.
Well, I've refrained from asking Mr. Horton why he hasn't done.
The wife has made a claim. Well, my lady, we touch on this matter in the introductory part of our written case, and the short answer is that the husband, although he has been through bankruptcy, is the beneficiary of very substantial family trusts.
But just pursuing Lady Hale's point, if the husband had made a claim in the Scottish divorce, would that affect this debate?
It might well. I think that would have depended on the nature of the claim that he'd made. But, Lord, that is a hypothetical. He didn't.
And is that because, on your theory of the case, that might make it a related action for the purposes of Article 13, or is it for some other reason?
Depending on the nature of the claim that he made, it might or might not.
Anyway, I interrupted you. You were talking about the favourable treatment given to the maintenance creditor in the maintenance regulation. Yes, we know that.
Whatever the background, for present purposes, it is the wife who is the maintenance creditor. And the first of the three cases is Farrell and Long, which is in Volume 5 at Divider 55, MS 1587. And this was cited by the Court of Appeal, and I think we can go straight to paragraph 69 of the judgment of the Court of Justice at 1597. Because this was a claim under the jurisdictional provisions were still the Brussels Convention. And it refers to Article 5.2, and the Court will remember that in Article 5.2 of the Convention and the original Brussels I regulation, then maintenance was part of the special jurisdiction, and the maintenance creditor was given the additional right which is referred to here. And the reasoning is explained that Article 5.2 is designed to relieve the maintenance creditor from having to bring proceedings in a distant court. There are two main reasons for this. First, the maintenance claimant is ex hypothesi, and in most cases in practice, the more impecunious of the parties to the proceedings, so that it seems fair that he or she should be spared the costs of an action abroad, including those incurred at the stage of the initial application. Secondly, the court for the place where the applicant is domiciled or resident is best placed by reason of its familiarity with the economic and social climate in which the applicant lives to make findings as to the reality and extent of the needs expressed. It is in a position to determine the merits of the application and to appraise the amount to be awarded. The second of the two authorities yes, I'm reminded that that refers back to a passage from the opinion of the Advocate General, but I don't think we have the opinion of the Advocate General in this authority. Oh, I'm sorry, that's the Advocate General. I'm so sorry.
You've already cited the Advocate General to us.
Yes. I'm sorry, my lady, the relevant passage in the judgment of the court, I'm so sorry, is paragraph 19 at page 1601. The derogation, it echoes the Advocate General in such close terms, I don't think I need to read it out again. Thank you.
These points about looking after the maintenance creditor are possibly more valid when she is living in England and he is the other possible jurisdiction is Greece, than when she is living in London and he is living in Dumbarton.
Well, my lord, except, of course, that certainly Brussels, and I think possibly also Paris, are actually closer to London than Edinburgh is. And the rule clearly applies to all member states. And so the question of, but we shall see in the case which we're about to come to, that even within a single member state, the question of proximity is still important. And so the question of whether there is a significant distance or a great distance is not what this is about. And that point is made clear in the decision of the Court of Justice in Sanders and Verhagen and Huber, which is at divider 59 in the same bundle, MS 1647. And the background to this case was that Germany had introduced a system of centralizing maintenance claims, perhaps not totally unlike our own system of centralizing divorces. But one reads Dusseldorf for Bury St. Edmunds. And what happened in this case was that two German claimants, one seeking spousal maintenance and the other child maintenance, made claims in their local court which were referred to the centralized courts, which were somewhat further away from their respective homes. And those courts, the centralized courts, referred to the Court of Justice the question of whether the process of centralization was compatible with the requirements of the maintenance regulation, and specifically the requirement that the claimant was entitled, the creditor is entitled to bring a claim in a court in proximity to where she lives. And and I say in passing, it happens that in these two conjoined cases, both the respondents to the applications lived abroad, one in another member state, one in a non-member state. But one might think that precisely the same question of policy arose, regardless of whether the respondent lived in Barbados, as was the case with one of the parties here, or as it might have been Munich. But in any event, the two courts referred this issue to the Court of Justice, and the Court of Justice, it's fair to say, didn't find it easy. But if we go on, I think, to paragraph 25 at 1653, it says that against that background, that's the factual background, Article 3b of the Maintenance Regulation must be interpreted in the light of its aims, wording, and the scheme of which it forms part. And then going down to paragraph 28, as regards the rules on jurisdiction in cross-border disputes concerning maintenance obligations, the Court has stated in the context of Article 5.2, and that's then the reference to Farrell and Long, and then at the end of paragraph 28, the rules on jurisdiction provided for in the maintenance regulation, like the rules set out in Article 5.2 of the Brussels Convention, are intended to ensure proximity between the creditor and the competent court, as the Advocate General has observed. And it then goes on at paragraph 30, and this is important to certainly relate, well, perhaps to more than one of the issues. Article 3b of the Maintenance Regulation specifies the criterion for identifying the court which has jurisdiction to rule on cross-border issues concerning maintenance obligations, namely the place where the creditor is habitually resident. That provision, which determines both international and territorial jurisdiction, seeks to unify the rules of conflict of jurisdiction. See to that judgment, to that effect, the judgment in the Collar-Drac case. And the court may remember that the Collar-Drac case was a commercial case which turned on Article 5.1b of Brussels I, dealing with contractual issues. But the Court of Justice said in Collar-Drac that Article 5.1b had territorial as well as international effect, and the court is here making the same point in relation to Article 3b of the Maintenance Regulation. Then it goes on to say, in 32, in this connection, it should be stated that although the rules of conflict of jurisdiction have been harmonized by the determination of all connecting factors, the identification of the competent court remains a matter for the member states, and then authorities are cited, but then, provided that the national legislation does not undermine the objectives of the maintenance regulation. And those objectives are clearly the ones which have been referred to, which are the creditor's right to choose a court and to choose a court in proximity to where she lives. So then the court goes on to deal with the specific German legislation. And I think we can pass over to paragraph 44. It says, secondly, a rule of jurisdiction, such as that at issue in the main proceedings, may serve to satisfy all three of the requirements set out in paragraphs 26 to 29 above, namely the introductions of measures to ensure the effective recovery of maintenance claims in cross-border situations, to preserve the interests of maintenance creditors, and to promote the proper administration of justice. And the court then, in effect, told the German court that it had to consider the national legislation in the light of that guidance which had been given. The third of the three cases which I would refer to is a very recent decision of the Court of Justice, cited as RVP, which is at Divider 61, page 1666. And this case involved two Romanian nationals. The wife was living in Belfast, but she brought proceedings in Romania, as we see at paragraph 19 of the judgment, with a triple purpose, seeking the dissolution of the marriage, the fixing of a place of residence for the child with her, and authorization to exercise sole parental responsibility, and an order for P, the respondent, to pay maintenance for the child. Now, the Romanian court was unable to exercise jurisdiction in relation to issues of parental responsibility because the child was habitually resident in Northern Ireland. And so the question which it referred to the Court of Justice was whether in those circumstances it could nevertheless exercise jurisdiction in relation to child maintenance. And if we go on to the section which starts at paragraph 28 at 1671, but I think we can pick it up at paragraph 30. In this connection, since the objective of Regulation 4.209, the maintenance regulation, as is apparent from recital 15 thereof, consists in preserving the interest of the maintenance creditor, who is regarded as the weaker party, etc., Article 3 of that regulation offers that party, when he acts as the applicant, the possibility of bringing his claim under basis of jurisdiction other than that provided for in Article 3A of that regulation. And then at 31, the maintenance creditor can thus bring his application either before the court for the place where the defendant is habitually resident in accordance with point A of Article 3, or before the court of the place where the creditor is habitually resident, in accordance with point B, or further, in accordance with points C and D, if the maintenance application is ancillary to a main action relating to the status, or under D, the court with jurisdiction in relation to children. And then, if we can go on to paragraph 42 at 1673, the court said this: so far as the scheme of the maintenance regulation is concerned, that regulation sets out in chapter 2 thereof, entitled Jurisdiction, all of the applicable rules to designate the court having jurisdiction with respect to maintenance obligations. Recital of that regulation stipulates in that, so recital 15 of that regulation stipulates in that regard that there should no longer be any referral to rules on jurisdiction in national law, since the rules resulting from that regulation must be considered to be exhaustive. So that is a very clear statement of the universal nature of the maintenance regulation. And then at 44, it must also be noted that the maintenance regulation does not provide for the option for a court with jurisdiction under one of the provisions of that regulation before which an application has legitimately been brought to decline jurisdiction with regard to that application in favour of a court which, in its view, would be better placed to hear the case, as Article 15 of regulation, that's Brussels II revised, permits in the matter of parental responsibility. And so that, we would say, is absolutely central in relation to both the second and third issues. And then at 45, such interpretation also corresponds to the objective of the maintenance regulation recalled in paragraph 30 above. As the Advocate General observed, that regulation provides for alternative and non-hierarchized criteria.
Is that a word?
Ugly, yes. That's really hideous. For jurisdiction which gives priority to the applicant's choice. So I think the court will already see why I say that this proposition of the degree of protection which is given to the maintenance creditor is a point which cuts across most, if not all, of the issues in this appeal. The second preliminary point which I would want to make relates to the background to and the terms of Schedule 6. And can we go, please, to Volume 5 for this purpose? Oh, I'm sorry, we're still in Volume 5. At Divider 66, now, this is the explanatory note. We've already looked at that, and Lord Wilson and Lady Hale were somewhat dubious about a passage in paragraph 7.3 of the explanatory note. That's a matter which I'm sure Sir James will be able to deal with much better than I can. I would tentatively suggest that it's not actually wrong to say that this follows the approach taken when the Brussels I regulation was applied in 2002, because
aligned, I think, not applied.
Aligned. I'm sorry, aligned. It is dealt with in a different way. But anyway, I will leave that to Sir James to deal with. That's obviously in his bailiwick. But what I would like the court to do is to go on to look at the transposition note, which I don't think you have been referred to, which is at page 1727. And to some extent, there's a degree of repetition, but paragraph 5 of the transposition note says, these regulations do not go beyond what is necessary to facilitate the application of the maintenance regulation in the United Kingdom, with one minor exception. Schedule 6, allocation within the UK of jurisdiction relating to maintenance, makes provision to align intra-UK jurisdictional rules with those of the maintenance regulation. This was done because certain key rules of Chapter 2 of the Maintenance Regulation, jurisdiction, which differ from the existing intra-UK rules, are likely to be directly applicable in any event, and it was decided to make provision to align the other intra-UK rules with the remaining rules of the Maintenance Regulation.
Are they calling Schedule 6 minor?
Yes.
Very well.
And there then follows on the next page, 1729, a table. And under Articles 3 to 14, under Objective, these provisions lay down the international rules of jurisdiction, power to make a maintenance order for courts in member states. There may no longer be reference to national law. That's Article 6 and Recital 15. And then it says under implementation, these rules are directly applicable. Certain rules in domestic legislation relating to maintenance relate to the international jurisdiction of a court in the UK to make maintenance orders. These are inconsistent with the requirements of Articles 3 to 14 and have therefore been amended. And in the items in the schedule which follow, it's number 6, which directly relates to Section 27 of the 1973 Act. And then finally, in these travaux préparatoires, we have the impact assessment, which starts at MS 1747. And we see that's dated the 21st of April 2011. And this, I believe, is in a fairly standard form. If we go to page 1748, under the box, the box in the middle of the page, what policy options have been considered, including any alternatives to regulation? Please justify preferred option. Further details in evidence base. Said an option of do nothing has been used as the baseline, but is not feasible because the 2009 regulation is directly binding on the UK as a matter of EU law and therefore must be implemented. The options for proportionate implementation are 1, implement only the strict letter of the regulation, 2, implement the regulation and update the existing intra-UK maintenance jurisdiction scheme, as was done for the existing Brussels I regulation that this replaces. The government considers option 2 is preferable, as it continues to provide one simple scheme for maintenance enforcement for both international and intra-UK cross-jurisdictional enforcement. Option 1 would create different regimes with potentially increased workload for the courts and practitioners. And then that is amplified if we go on to option 2 at 1761. And I'm not going to read this all out, but under the heading Intra-UK Maintenance Jurisdiction Scheme, at 3.61, it says not replicating these EU rules will mean that intra-UK cases will continue to broadly follow Brussels I, the existing regulation for EU cross-border cases. This will confuse matters as there will be 2 parallel systems and Brussels I will no longer apply to maintenance at the member state level. And then at 3.63, it refers to the intra-UK jurisdictional rules currently governed by a scheme which largely replicates the jurisdictional rules of Brussels I at intra-UK level. The intention behind this option is to update those rules to closely reflect the jurisdictional rules of the maintenance regulation, since that regulation will replace Brussels I. And then at the bottom of that paragraph, it is likely that the maintenance regulation has some direct effect as regards intra-UK jurisdiction, but in respect of some, not all of its provisions. And we analyse at paragraph 104 of our written case the respects in which the maintenance regulation does have direct effect, and that is picked up and adopted by the interveners in their written case.
You obviously know your way very well around all this material in tab 66. Where do we find the address of the forum non-convenience not being taken into the new system?
Well, my lord, what we find is, I mean, it's by the clearest implication, by saying that the system will be aligned to the maintenance regulation, that it follows inexorably from that, that since the EU regulation has no provision for forum convenience, that the intra-UK system will not have it either.
But it didn't before.
Quite. I mean, Section 49 had continued to inform this sort of issue up to the 1st June 2011. Do we see no address of whether it was valuable to continue it or proper to discontinue it?
Well, what we see is what we have seen. I think I've taken the court to the important passages. Maybe I've missed something out. But what we see is that the value of aligning the intra-UK system to the intra-EU system was regarded as the better option.
I think you're saying there is no reference to the material to which I was referring.
There is no direct reference.
Very well.
But it's more than that, isn't it? Because in a passage that you read to us, and what policy options have been considered and what the two options that they mentioned, they are proposing as option 2 something which is said to be as was done for the existing Brussels I regulation that this replaces. But it isn't, because there they preserved the forum non-convenience.
Well, my lady, of course, the focus of this appeal is on forum non-convenience, and so the absence of a direct reference to that may take on an importance which is perhaps disproportionate when one looks at the wider picture which was being dealt with when Schedule 6 was being brought in. When the focus is, when the magnifying glass is looking directly at the fly, it's easy not to think about the saucer which surrounds it.
But how many changes were there, in fact, between the previous regime under the judgments regulation and the present regime under the maintenance regulation?
I haven't done a quantitative comparison.
Well, it is rather relevant to the answer you've just given to my lady. If not a lot changed, well then, what was all the fuss about? If a lot changed, well then, one could see.
The pre-2011 position included a modified version of the Brussels I regulation in Schedule 4 of the 1982 Act. It was modified in a number of ways, but I'm afraid I haven't done the analysis to be able to say, well, this was changed, but this wasn't, and this was changed.
I'm sorry I asked.
No. I mean, one tries to cover all the angles in advance, but I'm afraid I haven't covered that one. So after those two preliminary points, I come on to the 4 issues. So far as the construction of Section 27 is concerned, if I can turn to our written case in core bundle, it starts at page 2151. And specifically, Section 27, subsection 2, the court may not entertain an application under this section unless it has jurisdiction to do so by virtue of the maintenance regulation and Schedule 6. Now, the appellant's entire case on this issue turns on that word "and." the use of and. And we would say that that is simply not the obvious and natural way to look at and. Because all that and means here is that it is a reflection that the same regime appears in both the maintenance regulation and Schedule 6. And there's no more to it than that. The consequence of the construction of which the appellant contends is drastic and we would say extraordinary. Because granted, as my lady has pointed out, that Section 27 is not the most commonly used provision in the Matrimonial Causes Act. Nevertheless, it is there on the statute book. We don't know how many unreported cases there are. And what it would mean is that any case which has been brought since the regulation came into force, and the maintenance regulation and the CJJMR came into force 8.5 years ago, has been brought without jurisdiction unless there was an international element to it, which is arbitrary in the extreme and extraordinary. And the position is even more extraordinary if we go to another family law statute which is much more commonly used than the Section 27, which is Schedule 1 of the Children Act. And we set that out in paragraph 38 of our written case. At the bottom of page 2153, where you have precisely the same jurisdictional provision. The court may not entertain the application or that part of it unless it has jurisdiction to do so by virtue of that regulation and that schedule. So it is...
But you haven't read the earlier bit. Mr. Horton's point is, and there are two further provisions that you deal with at B and C. Those provisions are, Mr. Horton says, just fine, because it's quite clear that the amendment is where you've got the application of the regulation or the regulations, then, of course, you mustn't do anything inconsistent with them. But he says there is actually a difference when you look at the way Section 27(2) has been amended, to which presumably you say it's an immaterial difference.
It's a distinction without a difference.
Or it's, I mean, they've not done their amendments consistently, but the intention is clear.
The intention, my Lord, is very clear. And I'm happy to go back to look at the first part of the paragraph 14.1 of the Children Act, because it says, if an application under paragraph 1 or 2, or part of such an application, relates to a matter where jurisdiction falls to be determined, etc. Well, it's, I would suggest, impossible to imagine an application under Schedule 1 of the Children Act which is not in the nature of maintenance, and therefore where jurisdiction does not fall to be determined by the maintenance regulation and or by Schedule 6. So in reality, paragraph 14.1 of Schedule 1 of the Children Act does apply to all applications. Because Schedule 1 entitles a parent to apply for maintenance for a child. Now, that maintenance may take the form of housing provision, but it's still maintenance within the meaning of Van den Bogaard. It's always going to be. So we would say that, yes, that the distinction which my learned friend Mr. Horton tries to introduce into these different jurisdictional provisions simply doesn't actually add up. But even if one only looks at Section 27, it is, we would say, inconceivable that a provision which was intended, as we've seen from the explanatory material, to align the UK legislation with the maintenance regulation and to bring it into force on an intra-UK basis, the idea that that statutory instrument had an incidental effect of depriving the court of jurisdiction in the majority of cases under Section 27, that cannot be right. Perhaps we should at this point actually look at Schedule 6, which is in Bundle 1 of the authorities, at Divider 3. No, I'm sorry. Yeah, Divider 6, I'm sorry. And Schedule 6 is at page 194. And paragraph 1 of Schedule 6, the provisions of this schedule have effect for determining, as between the parts of the United Kingdom, whether the courts of a particular part of the United Kingdom or any particular court in that part have or has jurisdiction in proceedings where the subject matter of the proceedings is maintenance. So it's, again, inconceivable that this schedule could have had the incidental effect of curtailing the jurisdiction of the English court, either in relation to Section 27 and or in relation to Schedule 1 of the Children Act. That is simply not what it's about. Then Lord Sales has already referred to paragraph 3 of Schedule 6.
You're leaving paragraph 1. I take your point in relation to this particular first issue, but when we see that the provisions of the schedule are to have an effect for determining which courts in a particular part of the UK have or has jurisdiction, we mustn't forget that the forum non-convenience inquiry is not an inquiry into whether a court has jurisdiction, but whether a court exercises jurisdiction. And so you read this and you think, well, it's not covering forum non-convenience at all. It's dealing with having or having jurisdiction.
Well, my Lord, if I may say so, that is a very fine distinction. But if we go on to paragraph 15, then we see, notwithstanding the preceding provisions of this schedule, the exercise of jurisdiction in any proceedings in a court in the United Kingdom is subject to the maintenance regulation. But since in practice what Schedule 6 did was to bring in not simply Articles 3 to 7 of the maintenance regulation, but also 12 and 13, I would suggest that in this context, where it says whether the courts of a particular part of the United Kingdom has or have jurisdiction, it must be taken to include the exercise of jurisdiction.
Well, I understand the point in relation to Article 13, which is clearly dealing with exercise.
Yes.
Nevertheless, the focus doesn't seem to have been on exercise, does it?
Well, my Lord, it was by what it did. By bringing in Articles 12 and 13, the focus was as much on exercise as on existence. Even if there is no specific reference to forum non-conveniens in the explanatory material, even if this refers to the existence of jurisdiction rather than the exercise of it, nevertheless, there we've got it, there they are, Articles 12 and 13.
Yes.
But I appreciate that this is going into what you might say is Sir James's territory, but it's removing, through this form of these regulations, what had been preserved through an Act of Parliament in the 1982 Act, Section 49, that is forum non-convenience.
Well, my lady, anything I say is certainly subject to anything that Sir James may say, but My understanding in relation to that is that that is what happens with the use of Section 2.2 of the 1972 Act, that the amendment of primary legislation is not in any way an exceptional use of Section 2.2. And the question which the court must look at for the exercise of Section 2.2 is whether what has been brought about arises out of or relates to the underlying EU legislation. And a comparison with what has gone before is not really the point. The question is, looking at it now, does it arise out of and is it related to the EU regulation?
But building on Lady Black's point that Section 49 appears to go, according to you, how long did Parliament have to consider these regulations? Was it 4 clear days?
It was, I know it was done at very short notice.
4 clear days?
My Lord, I can't be clear.
Very well.
But it was, I know it was done at short notice. I was one of the consultees for the regulation, and I know. But only on certain. So I know that it was a bit of a rush.
You didn't pick up on this point anyway, Mr. Scott.
No, we did pick up on Section 16.4 of the 1983 Act, but not on this point. But, my Lord, yes, it was done, but that again, Sir James will no doubt be dealing with this. As far as I know, that's not uncommon. But perhaps I shouldn't even say that.
But it wasn't done the first time round because it was preserved by statute. They didn't rely on the Section 2.2 at that point.
Well, I think, as far as I know, the order in 2001, which amended the 1982 Act, was under Section 2.2, I believe.
Yeah, okay.
Can you help me? Which is the provision, I assume it's in Schedule 4, which takes maintenance outside the 1982 Act? Is there such a provision?
Yes, there is. One has to look rather carefully. If one looks at the bottom of page 193, well, no, I'm sorry, it's a bit more than that, because in a sense it's what's not done, because where it says in Schedule 4, paragraph 2 and 3, there are reference to the regulation. Now, the regulation means the Brussels I regulation, so it's by failing to insert and the maintenance regulation that maintenance is taken out of the 1982 Act. It would have been necessary to add and the maintenance regulation. But then specifically, paragraph 11, where it says, Schedule 4, Chapter 2 of the regulation as modified for allocation of jurisdiction within the UK, paragraph 3b is repealed. Well, that is the passage in Schedule 4 which deals with the special jurisdiction under Article 5.2 of the original Brussels I regulation, and paragraph 3b referred to maintenance. So the other paragraphs of Article 5.2 of the Brussels I regulation remain in the 1982 Act, but the reference to maintenance is removed. So it's really by those two parallel routes.
Thank you.
So, my ladies, my lords, I don't know if there's anything else I can usefully say on issue 1. So I move on to issue 2, whether forum non conveniens is available in relation to another part of the UK. And of course, our starting point is that this was carefully considered by the Court of Appeal, and the judgment of the Court of Appeal was correct. Can we just look quickly at... before I come on to that, the Court of Appeal treated this rightly as a matter of statutory construction. And the question was whether, looking at Schedule 6, and to the extent, if at all, that is relevant, the 1982 Act in its modern form, whether there was any scope for forum non conveniens. If I can just refer the Court to how the appellant deals with this at one or two points in their written case. At 2116, at paragraph 38b of the written case, the appellants rightly accept that forum non conveniens is not a fundamental common law rule or right so as to attract a higher test. Instead, the issue of whether the provisions of a statute have been impliedly overridden or displaced the common law is a question of construction of the statute in question. And that's a citation from the CPAG case, which the Court has already looked at. And that, in my submission, is exactly correct. But at other points, a slightly different approach seems to creep in to the appellant's case. And so if we go on to paragraph 40 at 2119, it starts, did the 2011 regulations silently abrogate the deep-rooted doctrine of forum non conveniens? Well, that might not seem like emotional language to a non-lawyer, but it does seek to suggest under the table that this is in fact a right which is higher than, well, that it is something close to a fundamental common law rule of right, which was correctly disavowed a couple of pages earlier. Then at 2123, at paragraph 48a, about 8 lines down, there is a presumption against changes in the common law. Well, I think we may need to go back to have another quick look at the CPAG case, but I would say that that is not the appropriate way to look at it. What this issue is, as I've said, is a pure issue of statutory construction. And to reinforce that, can I refer to Cook and Virgin Media, which has been touched on but not really looked at, which is in volume 1 of the authorities, divider 12, page 339. Because this case was, in a sense, the mirror image of the present case, because this concerned two claims where there had been car accidents in Scotland, but the claimant wished to sue the defendant owners in England. And so the question was whether the English court could stay the proceedings in favour of the Scottish court. And it was treated by Lord Dyson in the Court of Appeal as being a pure question of statutory construction. And I think we only really need to look at paragraphs 32 and 33. Where Lord Dyson said, the insuperable stumbling block for the argument advanced by Mr. Mead is the express statutory preservation of the forum non conveniens doctrine in domestic cases by Section 49 of the 1982 Act. And then at 33, it follows that Section 49 provides a complete answer to the claimant's case in relation to the 1982 Act. So the court wasn't saying that forum or known convenience is available because it is a deep-rooted common law right. It is saying that it is available because the 1982 Act in its present form says that it is available.
And why did it say it was available?
It says it's available because Section 49 applies, and Section 49 says it's available.
No, I know that.
I'm sorry, my lady.
Why does Section 9 make it available?
I'm sorry, my lady. I've closed this. Let me go back to it.
I'm not sure that's explained in Cook and Virgin Media. But why does Section 49 preserve this power intra-UK to decline jurisdiction on forum non-convenience grounds?
Well, my lady, that may well be because of inherent differences in the Brussels I regulation and the maintenance regulation, a difference that the Brussels I regulation is based on a preference for the forum of the defendant. It is the defendant who has the whip hand and is entitled to be sued in their own forum, whereas under the maintenance regulation, it is the maintenance creditor who has a choice of fora, and so a different approach is called.
But Section 49 applies to both.
No, lady, Section 49 does not apply to the maintenance regulation.
Well, you say it doesn't.
Well, yes. I mean,
You say it doesn't.
that is our case.
Yes,
Well,
that is your case. But I was simply asking, the implication of my question was simply, does Section 49 preserve the forum non-convenience principle in the context in which it originally did so, and on the appellant's case still does so, because it's a fundamental principle of the rules governing conflicts or resolution of jurisdictional conflicts within the United Kingdom. Might that not be the reason why it exists?
well, my lady, with respect, no, it's not. It is not. And the appellants don't suggest that it is a fundamental right.
No, they don't say right, they say principle.
And perhaps that,
They don't say it's a court. I'm not sure that one has a right where it's a discretion, but
well, I suppose one has a right.
they use
to
some rather strong adjectives to describe the principle.
Well, my lady, I'm very happy to address you on whether Section 49 is applicable to the maintenance regulation.
No, I know you're going to do. Well, you might do that, or you might not do that. That wasn't the point I was getting at. I'm sorry. Forget it. It was a point of curiosity on my part.
Well, my lady, I mean, if the underlying point of your question was why is there a different approach to the Brussels I and, on the one hand, and maintenance regulation?
No, it wasn't. It was why was Section 49 there in the first place? That's the question that I asked.
Well,
It didn't have to be there.
no.
It wasn't compulsory to have it there.
I
So why
think-
was it there?
I don't think that's a question I can answer.
It's not only about forum non-convenience, Section 49 either, is it? It's forum non-convenience or otherwise. It's really broad. It says, nothing to prevent a court from staying any proceedings before it on the ground of forum non-convenience or otherwise. So it was a really broad provision. I don't know if that tells us anything about what it was doing there.
Well, that's the or otherwise isn't a point which has really been explored.
No, I understand that. It may be just indicating we don't actually know what it was doing there. Anyway, your case is it's not there anymore.
My case is that as a result of the amendments to the 1982 Act, which I addressed in answer to Lord Sale's question, but would happily go into more detail if it would be helpful, then maintenance and the maintenance regulation were entirely taken out of the 1982 Act. That was the conclusion which the Court of Appeal reached, and they were right. But of course, forum non-convenience has gone in all international areas. Intra-EU areas. So it's not that deep-suited a right. We've signed up to the EU regulations, which have entirely done away with forum non-convenience. And so the question, we would say, of whether that doing away with forum non-convenience in intra-UK cases is not really such a big deal as the appellants would have it. But I will come back to that in the context of issue 3. So what I would say is that the effect of Schedule 6 is to substitute one statutory regime for another. And of course, subject to the Villiers issue, which is a completely separate point, but subject to that, that is something which it was perfectly proper to do. And there is really no room for doubt about the effect of what that achieved. Because what that achieved was to introduce the maintenance regulation rules in the form of Articles 12 and 13 with no qualification and no modification. And it could have been done differently, but for reasons which are set out in the impact assessment, it was chosen to do it in a particular way. Your Lordship looks doubtful.
You say for reasons set out in the impact assessment. Half an hour ago, we agreed there are no reasons given for the obliteration of FNC.
Well, no, that is right, but the positive reasons for doing it in the way in which it was done are there.
Oh, well.
I think perhaps it would be helpful to go back to look at the CPAG case. That's Bundle 1 of the Authorities, Divider 11, page 320. I'm going to take this very quickly because the Court's looked at it before. But I think, as my learned friend Mr. Horton said, there are rather a lot of negatives in paragraph 71, and I think we do need to disentangle exactly what Lord Dyson was saying. He said, the question is whether, as a matter of statutory interpretation, Section 71 is an exclusive code for recovery of overpayments. Then that question is to be answered not by applying any presumptions or by saying that the common law remedy in restitution is not displaced unless, in Lord Hobhouse's words, as a matter of logic, it cannot coexist with the statutory regime for recovery. So what that is saying is you don't apply any presumptions, you don't apply any higher test, such as having to show that the common law remedy cannot coexist with the statutory regime for recovery. So it is a straight question of statutory construction. And I would, with respect to Lord Dyson, say that that is a clearer and better formulation than the alternative formulation at the end of paragraph 34.
So, forgive me, I didn't pick up the page reference to the...
I am sorry.
You were first. I picked up the page reference to the beginning of the case.
It's 336, my lady, paragraph 31.
Thank you. So you think paragraph 31 is clearer than paragraph 34?
Yes. I would say that looking at it as a question of pure statutory construction is the appropriate lens through which to approach the issue. And that...
Yes, but when you construe the statute, is not the question whether, looked at as a whole, a common law remedy would be incompatible with the statutory scheme, and therefore could not have been intended to coexist with it, which is the final sentence of paragraph 34. I mean, just to say it's a question of statutory construction gets you not very far.
Well, there we are.
When you have no express provision.
But mainly what we would say is that when you approach it as a matter of statutory construction, taking into account that the common law remedy was preserved by the 1982 Act up until 2011, but it is completely clear from looking at Schedule 6 taken together with the relevant passages from the 1982 Act that it was intended to exclude FNC. My learned friends say, well, it's not impossible to have a statutory, to have first in time and FNC coexisting. But the examples which they give of that are all examples where the two systems are spelt out in the same instrument. And one of those is Article 15 of Brussels II Revised, which provides that in exceptional cases that the court may transfer children proceedings, they're not divorce proceedings, to the courts for another member state. And another one that the example that the appellants give is paragraphs 8 and 9 of Schedule 1 to the Domicile and Matrimonial Proceedings Act 1973. But again, you have them both spelled out. Paragraph 8 requires the obligatory stay in certain limited circumstances intra-UK. Paragraph 9 provides for discretionary stays on a much wider basis. And similarly, in the Hague provisional text, I think it's called, you have Article 21, which says, which deals with the first in time, and Article 22, which says that in certain circumstances you can escape from that and apply FNC. So yes, it is not impossible for the two systems to coexist, but it's only going to work if they are both spelled out and if how they interact is both spelled out. And that is simply not the case here, because there is no modification of Articles 12 and 13 at all. There is nothing on the face of Schedule 6 which sits alongside them so as to provide for the continuation of FNC. And the question is not, why is there nothing which expressly removes it? But the question at this stage, at any rate, is there is nothing which expressly preserves it. So how can you say that it's been preserved?
Mr. Horton says that forum non-conveniens covers much more of the ground than Article 12 and 13. He says, for example, forum non-conveniens might lead to first state courts being seized, being stayed, whereas, as we know, Article 12 and 13 is only later courts seized. He says that forum non-conveniens can result in the stay of proceedings, even though there is, as yet, no rival proceedings. So he says it's bigger and wider, and why can't it exist underneath?
Well, my lord, there's no reason in principle why it couldn't coexist, but it would require an express statement that it coexists. Because we've looked at Schedule 6, we've looked at what it says. It says Article 12 of the Maintenance Regulation shall apply. Article 13 of the Maintenance Regulation shall apply. And one cannot read into Schedule 6 a superstructure of FNC.
What you've got to read into Schedule 6 is actually the exclusion of FNC, because FNC was expressly preserved in the previous legislation, which of course had the equivalence of Articles 12 and 13. So, as you quite rightly say, there's no reason in principle why they shouldn't coexist. What we have is the Schedule 4 of the 1992 Act being preserved expressly, subject to Schedule 6. So what you've got to look to in Schedule 6 is something that expressly takes Section 49 out, don't you?
Well, my lady, with respect, no.
Well, of course you don't. Of course you don't agree with that. You couldn't possibly agree with that, but never mind.
But I've also been looking to see what it is, because Section 49 is not mentioned at all in Schedule 4. And I've been looking to see what it is that removes all of this.
Well, my lady, let me take you to the CJA.
I think I probably missed out on when you were explaining how we got to this position in the first place.
Right.
Of losing Section 49
Well, let's simply look at the CJA, the 1982 Act, which is Volume 1, Divided 3, and it starts at page 20, but I think we can go to Section 16 at 27.
Well, it's section 16.4, isn't it?
Well, we can start with Section 16.1, because that says the provisions set out in Schedule 4, which contains a modified version of Schedule 2 of the regulation. Now, the regulation is defined in Section 1, which isn't included in the bundles, to mean the Brussels I regulation. Separate reference is made to the maintenance regulation, which is defined as the maintenance regulation, although it doesn't actually play any, as far as I can see, play any part in the modern Act. But Section 16.1, therefore, by referring only to the Brussels I regulation, means that that Schedule 4 does not apply to the maintenance regulation. And then...
Well, now does not apply to the maintenance regulation, but previously did.
Previously did, yes.
Well, previously applied to maintenance.
Yes.
Now does not apply to maintenance because of the maintenance
Exactly,
regulation.
my lady. Thank you, yes. Then we have Section 16.4, that the provisions of this section and Schedule 4 shall have effect subject to ... Schedule 6 to the Civil Jurisdiction and Judgment Maintenance Regulation. So Section 16.1, by omission, excludes the maintenance regulation, and Section 16.4, by express inclusion, excludes Schedule 6. And so, my lady, that's why we don't need to have any express reference to Section 49, because maintenance is taken out of the ambit of the 1982 Act at an anterior stage. Then we have Schedule 4, which is at page 45. And that is headed Chapter 2 of the regulation as modified, rules for allocation of jurisdiction within the UK. And then under paragraph 3 of Schedule 4, special jurisdiction, we see a line of 3 dots at little b, which is where the reference to maintenance used to be. So if I can go back to Lady Hale's question of do we need to look for an express removal of FNC, the answer in my submission is no, we don't, because we can see that maintenance is taken out of the 1982 Act, and we can see in Schedule 6 that Articles 12 and 13 are imported without qualification or modification, and the unavoidable, necessary consequence of that is that there is no room left for FNC. And we've seen, I think it's paragraph 15 of the preamble to the maintenance regulation, which says there may no longer be references to national law. Now, that, of course, is true as the maintenance regulation. But the whole scheme, the jurisdictional scheme, both as to the existence and exercise of jurisdiction in the maintenance regulation, is imported wholesale into Schedule 6. With the exception of Article 9 of the maintenance regulation, I don't know the reason for the omission of Article 9. It's not relevant in this case anyway, because there's no question about the sequence of seizing.
So what's seizing mean if we haven't got a definition of it?
Well, Lord, I think it's a reference back to national law. There was no definition, there was no equivalent to Article 9 and its analogue in Brussels I in the Brussels Convention. And so the courts then had to wrestle with this issue. Then the equivalent to Article 9 was introduced into the Brussels I regulation. And I just don't know why it doesn't appear in the maintenance regulation. But it doesn't matter. First of all, because the court can, when necessary, work out issues of seizing without an equivalent to Article 9. And I think the Brussels Convention case in this country, I think, was Dresser and Falcongate. But in any event, it is simply not an issue in this appeal.
Well, we've got to make some sense of 12 and 13, reference to seizing, so it would be nice to know how we should approach it. If our lodestar in Article 9 has been occluded, what do we do?
Well, my Lord, with respect, it's not a lodestar. Articles 12 and 13 are directly taken not only from the Brussels I regulation, but from the Brussels Convention. They are standard articles which appear in all the relevant EU instruments. And as I've said, in one such EU instrument, there was no equivalent to Article 9. So it is not, Article 9 is not, as the appellants would have it, a lodestar for the exercise of 12 and 13. It may be there, or here it happens not to be there. But that doesn't prevent the court from giving full weight to the meaning of Articles 12 and 13, which, of course, in the other regulations and under the Convention, have been the subject of a great deal of jurisprudence in the Court of Justice.
Why didn't Section 49 have a similar qualification to that in Section 16.4?
Well, I think the answer to that is that it wasn't necessary, because once you've got Section 16, then there was no need to amend Section 49.
That's on the basis that it removes maintenance from the 1982 Act. Is
Yes.
that the argument? Then why make it subject to Schedule 6
Well, because
if it's gone?
Because what Section 16.1 does, by failing to mention the maintenance regulation, is to show that that is excluded. But what 16.4 does is to show that that Schedule 6, the 1982 Act is also subject to Schedule 6. If that had not been there, then there would have been much more scope for the argument being advanced by the appellants.
But I don't see why you need, if you've taken maintenance out of this Act altogether, I don't see why you need to mention a purely maintenance provision here.
Well, because what you've done under Section 16 is to take the maintenance regulation out of the Act, but it could have been argued, if those words had not been added, what is in fact being argued now, which is that FNC has survived. But what we would say is that by including those words in Section 16.4 of the 1982 Act, that itself means that the Schedule 6 prevails over Section 16, and therefore one looks at Schedule 6, and the question is whether under Schedules, the question at this stage is not whether, as a result of the 1982 Act, FNC has survived, because the 1982 Act has nothing to do with the present situation.
Well, except that the 1982 Act, Section 16.4, refers you to Schedule 6, and Section 49 says that nothing in this Act shall prevent you having forum non-convenience. So, on that argument, you read the reference to Schedule 6 as being subject to Section 49.
May I go back to it? I'm afraid I've closed it, so let me go back to it.
It's at 43.
Thank you.
That's interesting, Mr. Scott, isn't it? The provisions of this section, we'll forget about Schedule 4, shall have effect subject to Schedule 6. It doesn't say all the provisions of this Act, just the provisions of this section. It doesn't refer to Section 49. It's not saying Section 49 is subject to Schedule 6.
Well, my lord, I take that point, but one has to look at the statutory scheme as a whole. And if the effect of the amendments to the 1982 Act were, as I suggest, the preliminary materials make clear that they were intended to be, and the text of Schedule 6 makes it clear that they are, then the fact that there is no specific exclusion of Section 49 does not change the overall situation.
But your difficulty is the width of Section 49. Nothing in this Act.
I mean, maybe the answer is that it is not because of anything in the Act that the court can't exercise FNC powers. It's because of what is in Schedule 6.
But you've been referred to by the Act. That's what sent you to Schedule 6.
Well, no, my lady, Schedule 6 stands by itself.
Oh, it does, but you've also been sent there and told it applied by Section 16.
Well, except that my Lord Wilson has made the point that it is not that Section 16, subsection 4, does not expressly refer to Section 49, but it may be that the reason that it didn't need to do that is because the exclusion of the FNC powers comes directly from Schedule 6, not from anything in the Act.
That's not quite my point. It's nothing in this Act is going to oust forum non-conveniens. That's what Section 49 says.
Yes.
Why do we look at Schedule 6 in the context of this Act? It's because Section 16.4 tells us to, and that is something in this Act.
Well, yes, but it says that the provisions of this section and Schedule 4 shall have effect subject to Section 6, but as Lord Wilson has said, this does not refer to Section 49. So far as Section 49 is concerned, we have to take a slightly different approach.
Okay.
And it is the words "nothing in this Act," which means that it's not necessary to refer to make that section subject to Schedule 6, because Schedule 6 speaks for itself.
It was rather the other way round that I was thinking of Schedule 6 being... Anyway, never mind. I see what you're saying. You're saying it's absent from Schedule 6, therefore that's the end of the point.
Yes.
I understand that.
And there is nothing in Schedule 6 which says, or could be taken, or could be read as meaning, that it is subject to Section 49 of the 1982 Act. I think the phrase the Court of Appeal used was that maintenance has been uncoupled from the 1982 Act. And that is perhaps the higher level, the broader way of looking at it. Unless there's any other points where I could help on issue 2, I'll come to start on issue 3, the Villiers issue. Now, I think perhaps a starting point here is that the intervener suggests, and if we could look at the case for the intervener, from paragraph 25, page 2193 onwards, that there are arguments in favour of the jurisdiction provision of the maintenance regulation having direct effect in intra-UK cases. Well, we've already seen that in a certain sense that is true. But this particular argument which is advanced by the intervener is not one which we've advanced. If it's a route which the court chooses to go down, then of course we'll be very happy. But I shall leave it to Sir James to develop that argument.
Well, we wanted to get absolutely clear whether you stand by paragraph 42A. The maintenance regulation does not have direct effect in relation to allocation of jurisdiction as between the 3 UK jurisdictions. This is correct. You are still saying that.
My Lord, this is paragraph 42A of our written case.
Indeed.
Forgive me if I find that. My Lord, what I'm saying is, I am aware that we said that, and so I do not seek to do more than formally adopt the submissions of the intervener which go beyond that.
Oh, if you formally adopt the intervener submissions, you are going back on that, as you are entitled to do.
My Lord, I do, but only to the extent of saying, there it is, we hadn't thought of this argument, so if that is correct, then we will certainly not argue against it. But it is not in the forefront of our case.
Because originally you didn't think anything of it. Yes, fair enough. You know, people find that.
Well,
It's quite
Lady,
common.
I have to say it would be fairer to say not that we didn't think anything of it, but that we didn't think of it.
Well, you made a fairly positive statement. You must have thought of it.
Well, anyway.
People don't put things in their written cases without having thought about it.
Can I then go on to the half a cake point? The extent to which the appellants accept that the CJ, or Schedule 6, is intra vires, in our submission makes it very difficult for them to argue that this one limited part, we assume for this ex hypothesis at this stage, that FNC has been removed. Because that is only one part of the wider package of the importation of the overall scheme of the maintenance regulation. And it cannot sensibly be severed from the rest. It gives rise, and this is definitely not my department, but in their final paragraph of their written case, the interveners say that they would like to wish to make further submissions if the court were to go down this route about exactly what was involved. And one can see, without treading on Sir James's toes, that it would actually be really very difficult to see how it could be expressed that that part of Schedule 6 is ultra vires, whereas the rest is not. And so we would suggest that the appellants were not able to get round that point when Lord Wilson put it to them. Subject, I accept, to the absence of a specific reference to forum non conveniens, the explanatory memo and the associated documents do go to some trouble to explain the positive reasons why the course was adopted of including Schedule 6. And, of course, it's not conclusive that the government thought about it very carefully and that they took the policy decision up to a high level, as we learn. But it certainly should give the court considerable pause for consideration if the matter has been considered with that level of care before considering that it might be ultra vires. And as to what is said in the preparatory materials about the intra-UK effects of the maintenance regulation, I think I've already touched on that, particularly in relation to Article 3, which refers to the place where the maintenance creditor is resident. And I referred in passing to the Colour-Drac case, which makes it clear that that formulation has intra-member state effect. So there were very good reasons to think that confusion would be brought about if the jurisdictional regime of the maintenance regulation was not imported into intra-UK cases. And so that then leads on to, and I'm not going to go to any of the authorities, but there is no real issue between any of the parties about what the law is in relation to ultra vires section 22B of the 1972 Act, because there have been a lot of cases on it. Nolan is the one from this court, but Oakley in the Court of Appeal is one which is much referred to. And it was said in Oakley that section 22B enables further measures to be taken which naturally arise from or closely relate to the primary purpose being achieved. Well, we would say that it's hard to think of a better example of that test than extending the provisions of the maintenance regulation to intra-UK cases. That's what that means. That may be all that I have to say about issue 3, but in any event, I notice it's 2 minutes
You notice the
before.
time, do you not? Yes. Well, do you wish to reserve your position in case you want to make a few further remarks about
I
this
would
issue
like to, and of
tomorrow
course
morning?
I've still got issue 4 to deal with.
You have indeed,
I've still
yes.
still got my time left. I may well be less than my full time, so if I want to, if I may, I keep some of that if necessary to go back to the vires issue.
Very well, thank you. The court will now adjourn.